All right. Hello, this is David Olshan from Nevada Legal Services. This live stream, we're going to cover consumer bankruptcy. And if you need legal assistance, free legal assistance, please visit our website at nevadalegalservices.org. I will be going through some of the features of Nevada and federal bankruptcy law. And if you have trouble paying your debts, and it's simply not something that you'll be able to repay in the near future, if you worry about that, if you get creditors harassing you, bankruptcy may be for you. So please stay tuned. Hopefully this won't be too long or too complicated. If you have questions, you can post them on our YouTube channel and we'll answer them. And of course, you can always go to our website at nevadalegalservices.org, fill out an intake, and we provide free legal assistance to file a Chapter 7 or Chapter 13 bankruptcy. Okay. So basically, bankruptcy allows you a fresh start. That's the federal mandate. Federal law does provide for bankruptcy courts and the ability to file a Chapter 7 or a Chapter 13 bankruptcy, consumer bankruptcy. The costs are rather limited. First of all, again, we provide free legal assistance. Sometimes if you retain an attorney, it'll cost between $500 and $1,000. So it may be a lot cheaper to go with us. You will have to take a consumer education and financial management class. Those are about $35 together. If your income is 150% of the poverty rate or below, and you can't pay the filing fee by installments, the judge will allow to waive the fee, which is $338 for a Chapter 7 and $313 for a Chapter 13. The question for a lot of people is, does bankruptcy make sense? It will stop bill collectors from calling. It will stop the garnishment of your wages so you can take home more of your pay. It will stop a pending lawsuit to collect a debt. And what it also allows you to do is stop paying unsecured creditors like payday loans, credit cards, and medical bills. And it can also help you save your home and your car from repossession and your home from foreclosure. If you file for bankruptcy protection, you may be able to save it in a Chapter 13 or just discharge the debt in a Chapter 7. Sometimes there are good reasons, legal reasons not to file if you're judgment proof. And basically that means Nevada exemption law exempts all your income and assets from creditors. If you get sued, you have a sort of mini superpower, and that is your judgment proof. So your income, it may be like Social Security. A debt collector can't collect that, can't take it to satisfy a judgment or any type of debt. If your savings account has less than $10,000 in it, there's a wild card exemption in Nevada up to $10,000. So you would be judgment proof. If you are sick or going into the hospital for surgery, if you have a divorce that's impending, it's in the near future, that's another reason not to file for bankruptcy protection. Also, what's known as strategic inaction. Perhaps you are waiting to discharge a tax debt. We'll go into discharging taxes in a few minutes, but if you're waiting to discharge taxes, or you just moved to Nevada, you may be wanting to use Nevada exemption law, that's another reason to wait. Finally, if you have purchased a luxury item recently or got a cash advance on a credit card, this may be a preferential payment or potential fraud, so you want to wait. There's a look back period of 90 days. So if you have done that in the near future, you would want to wait to file for bankruptcy protection. And of course, consulting with an attorney, consulting with us at Nevada Legal Services, we can tell you whether it is advantageous to not file and to wait. Oh, shoot. All right. So prerequisites. If you're thinking about filing, it's generally better to have lived in Nevada for 180 days. That's the venue statute. You can file in Nevada if you've lived here for 6 months. It's better if you've lived here for 2 years, because then you would be eligible for Nevada exemptions. If you haven't lived here for 2 years, we're going to look back to where you did live, and we'll get into Nevada exemptions. You need to take a credit counseling class. That you can do that online. Again, the cost of credit counseling and financial management is $35. The first class credit counseling is usually about $20. Also, to file for Chapter 7 protection, your income must be at or below the means test. And currently in 2021, for a one-person household, that's $54,000 approximately. So it's pretty high. It's basically the mean average income. It's the mean income for this area. It's not the average income. And in May of 2022, that standard will be increased because of inflation. So if you have a two-person household, it's $69,000, three people, it's $77,000. So if your income is higher than that, your annual income is higher than that, you probably will be pushed into a Chapter 13. So just be advised that if your income is too high, you may not be eligible for a Chapter 7. Some of the great features are it will stop all collection efforts. If you get harassing phone calls from creditors, a bankruptcy will stop that. If a creditor continues to try to call you, that is a violation of the automatic stay, and you can sue the creditor. And that's, the major reason why creditors cease when you file for bankruptcy is because of the automatic stay. Also, in bankruptcy court, there's a presumption that you should get a fresh start, that you can eliminate the debt. So if you're used to going to court and being treated unfairly, it's really not the way in bankruptcy court. There is this presumption that you should get a fresh start and you should be eligible for a discharge under the bankruptcy laws. If you have had more than $600 garnished in the last 3 months, you can get that money back in a bankruptcy, and that's very useful. Also, if you have an overpayment from the Employment Security Division based on unemployment benefits, or if you're facing an eviction from a housing authority, you can discharge that debt, and you wouldn't necessarily be evicted from the housing authority or have to pay the Employment Security Division back, because that debt would be discharged in a bankruptcy. Another barrier to filing for bankruptcy protection is if you filed recently. If you previously filed a Chapter 7, you have to wait 8 years to file another. And if you want to file a Chapter 13 after a Chapter 7, you have to wait 4 years. If you filed a Chapter 13, you have to wait 2 years to file another Chapter 13 and 4 years to file a Chapter 7. Keep in mind the Bankruptcy Abuse and Consumer Protection Act of 2005 places a lot of emphasis on the Chapter 13. It made it harder for debtors to file for bankruptcy protection, and it basically pushed a lot of debtors into Chapter 13, where you pay your creditors back over a 3 to 5 year plan. So this is a quick snapshot of the Chapter 7 process. You have to attend the credit counseling class. You have to fill out the bankruptcy petition and all the other forms that are needed. There's approximately 15 to 20 forms, a listing of your assets, a listing of your debts, a listing of your income and your expenses, whether you want to reaffirm debts. There's a means test to make sure that your income is below the mean income for this area. A lot of this is if you have your affairs in order, if you have your bank statements and tax forms and things like that, this process can be easy, and filling out the paperwork is not that difficult. Once you file the paperwork, usually within 30 days, there's a meeting of the creditors. And basically what you do at the meeting of the creditors is simply answer questions. It's 5 to 10 minutes where the trustee will ask you, did you fill out the bankruptcy paperwork? Is it true and correct? Did you list all your income and your debts? Whether you have to pay child support or alimony, questions like that. It's basically for the trustee to make sure that you're not committing fraud and you've revealed all your income and debts, so that the bankruptcy paperwork is correct and that everything is listed and everything is pretty much fine. The trustee is a private attorney who acts on behalf of the bankruptcy court to make sure basically that you filled out the paperwork correctly. After the meeting of the creditors, you usually then take the financial management class, and then your discharge is usually 60 days after the meeting of the creditors. So Chapter 7 is pretty much a 3-month process. It's quick and it's easy. The Chapter 13 process, as I indicated earlier, there's a 3 or 5 year plan, and it takes a lot longer. And through that plan, you're paying your creditors back. So, as I said, 2005 Bankruptcy Abuse and Consumer Protection Act really pushed a lot of good faith debtors into a Chapter 13, and it made it more difficult to file for bankruptcy protection. The filing fees, again, for Chapter 7 are $338. If you want a fee waiver, your income must be 150% of poverty rate or less. For 2022, a family of one, that's $1,700 a month. For a family of 4, it's $3,500 a month. And that's the poverty rate plus 1/2 or 150% of the poverty rate. If you are above that, also keep in mind, if your income is below 150%, you also can't make the payments based on savings or excess income. So you're going to allege when you file for that fee waiver that your income is below 150% of the poverty rate, and you can't pay the filing fee by installments. If you don't qualify for the fee waiver, you can still pay the filing fee by installments, and it's 3 payments of $80 and a last payment of $98. And those payments are every 30 days, so you have to sort of pay the filing fee of $338 within 4 months of filing. You won't get a discharge until you're finished making the payments. So this is what I talked about, the meeting of the creditors. It's usually 5 or 10 minutes. Before the meeting of the creditors, you have to usually supply 6 months of bank statements, two pay stubs or some proof of income, 2 years of tax forms, a copy of your driver's license and social security card, and you must fill out a trustee's questionnaire. Now, usually because of the pandemic, these meetings of the creditors have been by Zoom, and they're much easier. You call in or you appear on Zoom, and you basically answer the questions over the phone or by Zoom. The trustee will swear you in and ask the questions, as I indicated before. Did you fill out the bankruptcy paperwork? Is it true and correct to the best of your knowledge? Did you list all your income and assets? Why are you filing for bankruptcy? Questions like that. This is the only hearing, this is the only participation with the bankruptcy court that's needed in a Chapter 7 case. So if you can get through the meeting of the creditors, it's pretty much downhill. There's 60 days before the discharge, assuming that all your forms were correct and you don't have anything more to do except take the financial management class. All right, secured debts in a bankruptcy and how they're treated. What we're talking about here are usually cars. You buy a car, you have payments. The car dealer has a lien on the car and can repossess it if you don't make the payments. Home is the same thing. There's a mortgage. Everyone sort of knows what a mortgage is. It's a secured interest on your home, and if you don't make the payments, the creditor, the mortgage company, can foreclose. Also keep in mind a vacuum cleaner. If you buy a vacuum cleaner, it may be secured. Kirby or some other high-end vacuum cleaners, they put a security interest. So check the documents you signed when you purchase it. There may be a security interest. And also credit union accounts. Credit unions are the worst thing when you go into bankruptcy. They have special protections, and they also have special terms. And you think a credit union is your friend, that's just false. Credit unions are probably the worst place to keep your money, especially if you're low income. And they do have a lien on all of your property. So if you have an overdraft, they can satisfy that overdraft and it doesn't violate the automatic stay. So be advised that if you currently have an overdraft, don't file for bankruptcy, close your account, open it up in a regular bank, and that's not a credit union, and you'll be protected. Secured debts in a bankruptcy, there's 3 different sort of statuses you can take. You can redeem the person, if you have secured personal property, you can reaffirm the debt. I had a client who had tires and she wanted to reaffirm the tire contract. It's very rare for a creditor to come out and take your tires off your car, but she wanted to reaffirm and she was able to do that. You can also redeem, which is pay the reasonable value of the property and you get it free and clear. or you can ride through. Cars in Nevada, if you're current with the payment, you can ride through, and that is not reaffirm or not redeem. You just continue to make the payments and nothing happens. You can also ride through with real property. If you're current with your house payments, you can ride through and not reaffirm the debt. And keep in mind, reaffirmation, many creditors abuse this process. So if you sign a reaffirmation agreement, you're not represented, you're going to have to go to a hearing in bankruptcy court. So be advised, a reaffirmation takes the debt out of the bankruptcy, and even though you may agree to it, a judge may deny it, which means you're not able to do the reaffirmation, which is probably in your best interest because it does take the debt out of the bankruptcy and it's not discharged when all your other debts are discharged. All right, we talked before about taxes and strategic inaction. You can discharge taxes in a bankruptcy, federal taxes. Basically, if you file your taxes every year, and it's more than 3 years since the tax was due, and it's more than 2 years since you filed the tax return, and the IRS has tried to collect for more than 240 days, which is 3/4 of a year, let's say, you can discharge those taxes in a bankruptcy. So a lot of it depends on your diligence as a taxpayer. The tax code does allow you to discharge the debt, but only if you filed your taxes. And by filing the taxes, it's you. Sometimes the IRS will file on your behalf. That doesn't count. So if you filed your taxes more than 2 years have elapsed since you filed your tax returns, and it's more than 3 years since the tax was due, and the IRS has tried to collect, then you're eligible to discharge that tax in a bankruptcy. All right. Again, redemption for personal property, like a car or a vacuum cleaner. Let's say you bought a car in 2012 for $10,000. You owe $9,000 on it now, but it's only worth $5,000. If you can come up with that $5,000 or get a loan for the $5,000, that's all you will owe. And you redeem the car in the bankruptcy, you only owe $5,000, and it really cuts your monthly payments, and it's really a good feature if you want to pursue it. And there are companies that will lend you money, specifically if you're in bankruptcy, to allow you to redeem and reduce the amount that you owe, reduce the principal, sometimes by half, sometimes more with some cars. Cars depreciate as soon as you drive them off the lot. So this is a good feature if you want to pursue it in a Chapter 7. Okay, preferences. If you've had more than $600 garnished within the 3 months prior to filing a bankruptcy, you can get that money back. So not all is not lost if you've had that garnishment and it's been going on. If more than $600 has been taken from you, you can recover it in a bankruptcy. And if you've made a preferential payment, if you paid one creditor over another, that's called a preference. A preferential payment can be unwound by the bankruptcy trustee, and the trustee will force the creditor to pay that money back, and it will be distributed to the other creditors because it's a preference. If you borrow money from a relative and pay that back before filing for bankruptcy, that may be unwound. So you have to be careful. If you have assets and you've made a big payment to a relative prior to filing for bankruptcy, that relative may have to pay the trustee because that is a preference. All right, we're going to move right along. Bankruptcy discrimination. So a lot of people wonder, can I lose my job because I filed for bankruptcy? Well, under federal law, a government unit cannot deny an SBA loan, or a housing authority can't evict you. Bankruptcy discrimination is outlawed under federal law, but a private employer may have the ability to fire you. So just be advised that if you're working for a government, especially a federal government, they can't fire you because of your bankruptcy filing. They can't deny you an SBA loan because of your bankruptcy filing or a student loan, but a private employer may be able to do that. All right, bankruptcy fraud, when you don't disclose all of your income or assets, or you try to hide them. Some people will transfer title to a home to a relative prior to filing for bankruptcy. That's garden variety fraud, and you will be sort of, not will be, but there's a good chance that you will be discovered when you file this bankruptcy. So it's a good idea not to rearrange your property or give a car away, do any type of major sort of transaction like that prior to filing for bankruptcy, because the trustee will usually find out and unwind that, and you could be charged with bankruptcy fraud and denied a discharge, or even go to jail, because bankruptcy fraud is a crime. And again, you must disclose all your assets and debts. You must list all your assets and debts. In Nevada, even if your spouse is not filing, you must list your spouse's assets and debts. And the failure to list these debts may result in the denial of a bankruptcy discharge. All right, let's skip to some of the exemptions you have under Nevada law. Currently, there's $605,000 in equity that you have in your house that is exempt from creditors. We talked before about being judgment proof. So if you have some equity and it's not above $605,000, then a creditor couldn't sell your home and take the equity from you because it's exempt. The point is, with these homesteads, you will have to file a declaration of homestead. We can help you with that at Nevada Legal Services for free. There's also other services that charge you for a homestead, but you do get to exempt up to $605,000. If you have a mobile home or condominium, you don't own the property that the homestead is on, you don't have to file a homestead declaration. You still have that $605,000 exemption. Nevada is pretty generous in terms of its exemption law. Household goods, there's a $12,000 exemption. That's your furniture, your clothing, your electronics. Your motor vehicle has $15,000 in equity. If it's equipped for a disabled person, there's no limit on the exemption. Earned income tax credit, wrongful death awards, $1 million in a pension or retirement fund. Public employees' pensions are usually exempt. $10,000 in tools for work, tools of the trade. Life insurance. Let's talk about the wildcard exemption. Wildcard exemption applies to anything that's not exempt. So it could be a bank account, because bank accounts aren't exempt. But if you have $16,000 in equity in a car, that $1,000 could be covered by the wildcard exemption. And it does go up to over $10,000, and it applies to any asset. So if you've got $5,000 in the bank, that's exempt because Nevada has a $10,000 wildcard exemption. Chapter 7, discharge. Discharges unsecured debt, meaning credit card balances, medical bills, payday loans, personal loans. Some debts aren't discharged, however. Most student loans aren't discharged. Alimony or child support is not discharged. Court judgments that are based on injury or death or death as a result of DUI, and debts that have been incurred fraudulently. For some of these, the creditor will have to go to bankruptcy court and file an adversary proceeding, like fraudulently incurred debts. You need a bankruptcy court to determine that it was fraudulently incurred. Keep in mind that if you have a fraud overpayment with the Nevada Department of Employment Training and Rehabilitation, DETR, that still may be discharged. The division's fraud determination is not binding on the bankruptcy court. So if you have a fraud overpayment, that may be discharged in a bankruptcy. All right, so if you're going through an eviction, the eviction won't permanently stop. The bankruptcy won't permanently stop the eviction, but it will slow it down. So a landlord would have to go and lift the automatic stay. Also, if the landlord doesn't lift the automatic stay, yes, it would stop the eviction. So just keep in mind, some people do file a bankruptcy, Chapter 7 bankruptcy, to stop an eviction. It will stop it for a short period of time, but the landlord can lift the automatic stay. Let's see. All right. So, Brianna, do we have any questions or comments? take that as a no. If you want, if you have questions, please contact us. Our Las Vegas phone number is there. Also, fill out an intake if you want free bankruptcy representation, nevadalegalservices.org. And that should do it for now. If you have any questions, please post them to our YouTube channel, Nevada Legal Services Now. And we will have more live streams and more information available. And if you have any immediate questions, please go to our website.